was extolling the virtues of the popes and the kings and queens of England as heads of the church. And he said that there is a presumption that these people exercise their vast powers only for the benefit of the laity. Baron Acton disagreed and said that if at all there is a presumption the other way, and which increases as the power increases. And then comes the oft-quoted sentence, power tends to corrupt, and absolute power corrupts absolutely. The next sentence is also very pithy. Great men are often bad men. Interesting. Great men are often bad men, even though they may exercise influence and not authority. Now, written constitutions such as ours are meant to diffuse power and are meant to see that there is no power that is concentrated in the hands of one authority or individual to the detriment of others. In fact, our constitution is one of the most prolix. It has 395 articles and is in 22 parts, as many as 22 parts. The very first declaration in the first part, India, that is Bharat, shall be a union of states, gives you a very, very important principle of the diffusion of power, namely the federal principle. Article 3 then goes on to delineate what the states will be and what union territories will be. A union territory being a small area of governance directly by the center, either because it is not an autonomous unit because of financial difficulty or otherwise, and needs to be brought into full statehood if it is so possible. We still have some union territories which cannot, like the Lakshadweep Islands, for example. Apart from part 1, you have the great parts 3 and part 4. Now, part 3 is almost the conscience of the Constitution because it essentially delineates what citizens' fundamental rights are. And all these rights are to be exercised against the state, as we understand it. That is, the legislature and the executive. Part 4 deals with directive principles of state policy, which generally tell the legislatures of the country, both center and state, that it is important never to forget the common man, the weak man. It's very important to remember the weak man, weak in whichever sense, anti-majoritarian equally. And after parts 3 and 4, you have the great principle of separation of powers, which you have in parts 5 and 6. So in part 5, you have articles dealing with the executive central, the legislature central, and the judiciary, that is the Supreme Court. And in part 6, you have the same Montesquieuan division into 3 parts, where the states. And you also deal with subordinate courts, which shall be under the control, essentially, of the high courts. Now, apart from these parts, you have a very important part 11, which again then distributes legislative power between the union and the states, which we'll talk about a little later. You have part 15, which is crucial to understanding that this is a democratic country, because you have an election commission consisting of a chief election commissioner and at the moment 2 others who actually run the central and state elections that are to take place every 5 years to the Lok Sabha and to the state legislative assemblies. Apart from these provisions, you have emergency provisions as to when these great principles may be abrogated or abridged, depending on the situation in the country. And part 20, which deals with amendment, most important, which we'll also advert separately. Now, having given us this constitution, Dr. Ambedkar, one of the main draftsmen, said that what he has given us is a constitution which works, which is flexible, and which is strong. If it does not work, however, man is vile. Very strong words used. What has happened in the recent past in this country is most disturbing. And if I may only share with you 4 things that have happened this year itself. First, in the beginning of the year, you had a BBC documentary. In fact, you had 2 documentaries speaking about our present Prime Minister as Chief Minister of Gujarat. They were promptly banned. And after the ban, the BBC was harassed by having tax raids upon it. This is the first difficult, questionable incident that took place early this year. Later in the year, you had the Supreme Court decide as to how election commissioners should be appointed. Something very, very crucial. Because if election commissioners happen to be partisan, then there is no free and fair election and there is no democracy. So the Supreme Court stated in an interim order that until Parliament decides, because Article 324, which speaks of the conduct of elections, specifically says that until Parliament so decides, it shall be the President. Then went on to say that it would be fair if you are going to have independent persons as election commissioners, to have the President, to have the Prime Minister, to have the Chief Justice of India, and to have the leader of the opposition as the 3 persons who will now appoint election commissioners. Most unfortunately, we find that a bill was moved in the Rajya Sabha, which has now become an act. Of course, it will go to the Lok Sabha and become an act in no time, in which the Chief Justice is substituted by a minister appointed by the Prime Minister. Now, this is the second most disturbing feature, because if, as a matter of fact, you are going to get the Chief Election Commissioner and other election commissioners appointed in this fashion, free and fair elections are going to become a chimera. So this is the second disturbing fact that we found this year itself. The third disturbing fact that we found this year is a governor of a traditionally minority government state, that is Kerala, sitting over bills for periods of up to 23 months. When the Supreme Court rapped him on his knuckles, what did he do? There were 8 such bills. 1 bill was assented to. 7 bills were referred to the President. Now, this again is a very disturbing feature, because if there's a wholesale reference to the President, then the legislative activity of the states comes to a standstill. Because unlike a governor sending back a bill, and then after it is sent back, the governor then has to sign it. Once it lands up at the center's door and the center says no, that's the death. That's the death of the bill. It's over. So this was the third most disturbing feature this year. And the fourth had its impact, a tremendous impact on federalism, which was the recent Supreme Court judgment on the abrogation of Article 370. Now, the recent Supreme Court judgment I'll deal with a little later, but suffice it to say that the moment a state is divided into 2 union territories, which is what was done here, the first question is, why was this done? What was the need? Because you had already had president's rule in the state. You were administering it from the center. So why did you need this? You needed this because you wished to bypass a very, very important article in Article 356, sub-article 5. Now, 356 essentially deals with circumstances in which there is a constitutional breakdown in a state and the center takes over. But then it is hedged with conditions. One of the most important conditions being as to time. In no circumstance can it go beyond 1 year. This is very important to remember. In no circumstance, except two, which is given in 356.5. And neither of them obtain. First circumstance is that you should have a national emergency. And the second circumstance is that the election commission should say that elections are not possible in that state. Neither of which obtain. So how do you bypass this? You bypass it by this ingenious method of making the state union territories, where you have direct central control and no problem as to time. So essentially what has happened is that this could have continued until the Supreme Court decided the matter. In fact, it took 4 years for the Supreme Court to decide the matter. It was in 2019 that the state was declared as two union territories. The decision has just come. And elections, hopefully, are going to be held by September next year. So we have had no democratic government in this state for 5 years, which could have continued indefinitely. This is a very, very, very disturbing feature. And the Supreme Court did not decide this question. Now, it didn't decide the question because it said, we accept the assurance of the Solicitor General of India that statehood will follow very shortly and that elections will be held. Now, I remember I had said in Shreya Singhal, which was one of my early judgments, when a similar assurance was given to me by the very same Solicitor General, that governments may come and governments may go, but Section 66, capital A of the Information Technology Act goes on forever. What has happened here today is nothing less than this. The Solicitor General does not have the authority to bind any successor government. We are going to have a successor government from May next year. Second, and more importantly, he has no authority whatsoever to bind the legislature. And this is going to be a legislative act. So, to say we won't decide means in effect, you have decided. You have allowed this unconstitutional act to go forward for an indefinite period of time, and you have skirted Article 356.5. These are all very disturbing things. So let us now come back to a brief survey of what the Constitution says should be done in order to diffuse power and in order to see that things like this don't happen. But then they have happened. If we go to the very first article, which I started with, that India shall be a union of states, the legislative power of the union versus the states is dealt with in Part 11. And it is divided very neatly. You begin with Article 245, which says that Parliament makes laws for the entirety of the country or some part thereof. States make laws for the territory of a state. And that they will have the power to do so depending upon whether the particular subject matter is contained in their legislative list. The union's legislative list is list 1 in the 7th schedule and consists of 97 entries. It deals essentially with matters of national import as opposed to regional import, national defense, banking, and many, many subjects which are of import for the country as a whole. The state list, for which the state legislatures have exclusive power also, is contained in list 2. It's a shorter list of 66 entries and essentially deals with things like police, public order, local self-government, etc. List 3 is a concurrent power where both the center and the states may legislate. You have subjects like education, forests, criminal law, contracts, etc. Now, having delineated these spheres, which is why we are really a quasi-federal setup. Why quasi? Because there is a tilt towards the center, which I will tell you about. And that tilt comes in by Article 248 straight away, which is the residuary article. That everything that you do not find in the state list, Parliament may then legislate upon. So residuary powers which are not mentioned in the list are left only to the center. The tilt becomes more pronounced as we go forward. You have Article 249 then, where the Rajya Sabha may, by a 2/3 resolution, pick up any one matter in the state list and say that henceforth Parliament will legislate, not the states. Article 250 is when emergency powers are used. And when there's a national emergency, then it may become necessary because of some external aggression or because of armed rebellion within the country for Parliament to legislate on exclusively state matters. Under 252, you have a concept of states giving up their legislative rights to Parliament. Like the Urban Sealing Act, for example, was made because land, though a state entry 18, list 2, was further subdivided into urban land, and urban land given up to the center so that you could have a uniform law way urban land in the entire nation. Under Article 253, even though a treaty may be made with another nation dealing with a state subject, Parliament is given the power to ultimately legislate, notwithstanding this scheme that we have. And finally, in Article 254, when the concurrent list is used, usually if there is a repugnance between parliamentary and state legislation, parliamentary legislation has to prevail, with a proviso that if the president says that this particular state legislation should prevail in that particular state, then the state legislation prevails. Now, this is the broad scheme of division of legislative subjects. And you see how there is therefore a quasi-federal setup where states have exclusive powers to make laws within their ken. What happens when we come to legislative activity in the houses of parliament and in the Vidhan Sabhas of the states? First, parliament. Article 79 declares that parliament itself consists of 3 organs: the president, the House of the People, and the Council of States, Lok Sabha and Rajya Sabha, respectively. It then goes on to tell us in Article 80 that the Rajya Sabha will be made up of 238 members, essentially who are elected by legislative assembly members themselves. And you will also have 12 others who will be otherwise taken from the union territories. So far as the Lok Sabha is concerned, you have a huge mammoth of 550 members, 530 of which are directly elected. And of course, the constituencies are based on population, so that you have UP, for example, having 80 seats because it's the most populous, and some northeastern states having 1 seat, Nagaland, for example, because they're the least populous. So the important principle so far as these houses is concerned is that whereas one dissolves every 5 years, the Lok Sabha, so that fresh elections can be held, very crucial thing for democracy, the Rajya Sabha continues, never dissolves, because it has an automatic dissolution of 1/3 every 2 years. And then a re-election so far as that 1/3 is concerned. And that's how these 2 houses then ultimately govern our country. Now, most importantly, a bill can originate in either house, but has to be passed by a majority of both houses. This is a very real safeguard, because though there may be a party in the center who is overwhelmingly elected, that party may not have the same strength in the Council of States. So that this acts as a real check to legislation. And therefore we have all bills except one, namely a money bill, which I'll tell you about immediately. A money bill essentially deals with all taxation and the consolidated fund of India, from which salaries are paid to everybody, executive, legislature, judiciary, etc. Now, a money bill originates only in the Lok Sabha. The Rajya Sabha is given 14 days to comment on it. If it says something, fine. It is then taken into account and ultimately the Lok Sabha can pass it notwithstanding what is said by the Rajya Sabha. Something like what obtains in the House of Lords today. In England, the House of Lords after 1911 and a 1949 Act is now reduced to a body which can only veto, in a sense, by sitting over a bill for a maximum period of 1 year. Because they know that if they make a comment or they say the bill should not be passed, then notwithstanding what they say, the Commons passes it. So that particular scheme is followed only with money bills, so far as we are concerned. And one other safeguard is that ultimately the president has to assent. If the president sends it back with some remarks, then again, the houses have to consider those remarks, and if finally they say, sorry, we disagree and we pass the bill, the president has no option. He must then assent. But nonetheless, it is a weak form of one further check. Now, so far as the states are concerned, and before we come to the states, there's one other interesting thing. Suppose there is a bill which originates in the Lok Sabha and the Rajya Sabha says no. Now, that's not an end of the matter, because the president may order a joint sitting of the two houses. And in a joint sitting, if it is then passed by the majority of those who happen to be present and voting, then the bill gets passed nevertheless. So with this caveat, you do have a very real check so far as the Rajya Sabha passing bills is concerned. When it comes to the states, unfortunately, there are very few states which have a legislative council, which is equivalent to the Rajya Sabha. All of them only have legislative assemblies. There are very few with councils. So you don't have bicameralism, so to speak. But even where you do, where the bill is sent to the legislative council and is sent back and then resent, if the legislative council says no the second time, then notwithstanding that they say no the second time, the legislative assembly prevails. So we have a very different scheme so far as the legislative assembly is concerned when compared with parliament. Now we come to the very interesting thing that I spoke about in the very beginning. What does a governor do when he assents to a bill? Now the governor, unlike the president, has three choices. One, he may either assent to the bill, or he may say no. In fact, he has four. Or he may send it back with some comment. Or he may refer to the bill to the president. Now, only the second proviso to Article 200 gives us some inkling of what kind of bill should be sent to the president. Second proviso says that if any legislation impacts the high courts, then compulsorily it has to be sent to the center. That gives you some idea of what the founding fathers had in mind when they said it is this type of bill that is sent to the center, not every bill. But then we have a judgment of our court, unfortunately, in B.K. Pavitra's case of 2019, which says that there is no constraint on the governor. The governor can go ahead and refer every bill if he wants to the president. According to me, this again requires a revisit. And it is important for the federal principle to work, for the Supreme Court to say in unmistakable terms that, look, this bill is going to ultimately find its death at the president's door, because the president says no, that's the end of the matter. So it is only such bills as impact the nation as a whole that require to be sent, and not others, or which impact the judiciary, which is what the proviso says. So if you constrain this power to send to the president, then again we are back on the rails. Otherwise, we are completely off the rails. If you have any governor in a state just wholesale sending bills to the president of India, who may then make legislative activity come to a complete standstill in an opposition state, where are we? So this is one other very, very important feature that we need to bear in mind. Now coming to the executive, the second great branch of government. We have a president who's the head of state. Now the president is elected, unlike a monarch. And the president is elected by an electoral college consisting of both the houses of parliament as well as the legislatures of the states. We are so concerned about the president as head of state that it is almost impossible to impeach him or her. Impeachment can take place only on the ground that he or she have violated the constitution. Ground is very broad. But you require a 2/3 majority of the entire house. That is the entire Rajya Sabha and the entire Lok Sabha. And what happens is procedurally, a charge is preferred for impeachment by one house. That charge has to have the requisite 2/3 strength of the entire house. The other house then takes up the charge. And if it is found valid, then 2/3 of that house, entire, again have to pass it. Something almost impossible. So you have ensured that your head of state remains in the saddle for 5 years. It's therefore very, very important to see that you elect somebody who is worthy of being head of state. Like, for example, Dr. Abdul Kalam. There should be a healthy constitutional convention where presidents, governors, etc., that ultimately you elect and or appoint, because governors are appointed, persons only of unimpeachable integrity who then fulfill the various functions they're supposed to fulfill under the constitution. And it is only when you have these people that they deserve this kind of protection, otherwise they don't. When you come to a governor, you have a very different scheme. A governor is not elected. Unfortunately, he is only appointed by the center. The article also says he is at the pleasure of the center. So despite the fact that he may have a 5-year term, it can get cut short at any point without reason. Now here again, there was a problem with the original constitution which the Supreme Court has tried to iron out. Because in a 2010 judgment, BP Singh's judgment, the court said that suppose you have got rid of a governor, which you are entitled to do. You don't have to give reasons. But suppose somebody comes to court and says that it is arbitrary, mala fide. Then you will have to tell the court as to why you did it. And you better have a very good reason. Because if you don't, the court will then strike it down. And this notwithstanding that the pleasure doctrine applies. So it was one very important step forward in seeing that independent governors are not thrown out. The corollary, according to me, is equally important. That you must see that a person who is appointed as a governor in the first place happens to be independent. Otherwise, the whole scheme collapses. Because he has two very important functions in his own discretion, which is apart from various other functions. One is what I just told you about, how he assents